Well, hello. Welcome back to another exciting edition of Coffee with Stephen. So, this week's blog is entitled The People v. Bocanegra. It's an interesting case. Potentially could have some implications for us. Although, to be quite candid with you, it's such a poorly reasoned decision. I'm not sure that it's going to dramatically affect Second Amendment jurisprudence. Um, Justice Oliver Wendell Holmes was famous for a quote: "Hard cases make bad law." This is a hard case, and the end result, especially from the judge of the Third Circuit Court of Appeals, is spectacularly bad law. Just to give you a brief background on this, Mr. Bocanegra and his good friend Vernon, they evidently share everything together, including each other's spouses, although evidently Mr. Bocanegra was unaware of this arrangement. So he decided to confront Vernon when he found out that his wife was cheating on him. He went to Vernon's house with an AR 15, a 1911, and a revolver. He brought the revolver with him as he approached the home, spoke to Vernon. Evidently, their dispute wasn't resolved, so he fired a couple of rounds into Vernon's house. Well, Mr. Bocanegra is subsequently arrested, and during the search of his vehicle, not only do they find the revolver and the 1911, but they also find the AR 15. Unfortunately for Mr. Bocanegra, his AR 15 was in its original configuration with a traditional magazine release. So he is prosecuted and convicted on a variety of offenses. One of them is possession of an assault weapon. This particular charge, he appeals to the Third Circuit Court of Appeals, and the judge, not wanting to get rid of this conviction, comes up with this bizarre theory, this absolute bastardization of the Bruin analysis to effectively state that AR-15s are not in common use. Now, what's interesting is that I'm not sure whether or not he was suggesting that AR-15s in their entirety are not in common use. He's more specifically stating that AR-15s that are not California compliant aren't in common use. This is an interesting sort of argument in and of itself. But more importantly, he goes into the analysis of saying that common use means for lawful purposes. Now, he's arguing, the judge is arguing that the AR 15 at that time was not being used for a lawful purpose. Therefore, no Second Amendment protections would be accrued to it. And since it is no longer protected by the Second Amendment, since it's currently not being used for a lawful purpose, it's perfectly acceptable to have the California legislature create these regulations to restrict how the configuration of an AR 15 is to be set up. No collapsible stock, pistol grip, so on and so forth. Effectively, what the judge has done is taken California's Assault Weapons Control Act and really make it nothing more than an enhancement to a predicate crime. Now, we could really get into the weeds on this particular decision, but it is so logically flawed that I'm not sure there's a tremendous amount of redeemable qualities behind it. But, it's kind of amusing to read. So I definitely encourage you to read the blog this week. As always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.